Hello everyone, welcome back to another episode of the Darrell Brooks saga. On today's episode, we're gonna continue with day one. This is I believe we're gonna see the opening statements now, so that's gonna be fun. But before that, I just want to tell you guys, thank you guys for watching, thank you guys for giving a like, thank you guys for posting your comments, and I really appreciate it. It really helps a lot. It really helps the channel a lot when you guys do that. Um, and announcements. We're gonna finish. I believe we're gonna be able to be finishing the next 3 videos with Darrell Brooks, and that will be it for him. So, and I got your suggestions, and yes, I'm gonna look into Sarah Boone. That's gonna be something that I'm gonna be looking at and making videos about it. There's also some secret project that I'm working on that I'm gonna post. I'm still not sure when. It's gonna be after the rel. But yeah, be on the lookout for that. With that, I just want to tell you guys that you matter, you're great. I'm glad that you guys are here. All right, let's get into the video.
After repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. He has forfeited his right to be present while we discuss all of these filings, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
Also, one note about all those filings that he's making. Like, remember, all this time he's been saying, that's not my name, I don't recognize the name, all of that. All of those papers that she's reading, they're signed Darrell Brooks. So that's the one thing that I never get, is that he signs that name and then he says that he doesn't recognize it. So which one is it? So if these papers are not from you, then I should just throw him away. They're not relevant to this case.
No, Your Honor. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts.
And that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom. Not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next.
Yeah, and this is the one thing that he always should have in mind. Like every time that he has in all the days that can come after this, is that she already answered this. Like that's there. Every decision that she makes is one. So whatever.
One. And he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. And therefore, I will deny the requests in that piece of paper summarily without further consideration.
That's also the one thing that he doesn't understand. He doesn't understand how to make motions. Like, just putting motion to do something is meaningless. Like, she doesn't know how to act on that because he doesn't tell her what he wants out of that. So
I know he makes repeated objection to either how I say his name or how it's referenced in the caption. This court will refer to the name that is on the information in this case. That is the official charging document. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. Frankly, his last document, which says a plea is to argue facts, I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. I will note Mr. Brooks continues to have the objection sign raised. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record to reflect, he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record?
yes.
You are. If you would please address my question.
Yes, no?
So you want me to come back over there just to get brought back over here?
No, that's not what she wants. She wants to know if you want to behave, just sit there and listen while everything else is going on, instead of behaving like a child. That's all.
That's not what I asked you, sir. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
It's a yes or no question, and I believe that at this point she should have been like, okay, you want to stay there? Stay there. Whatever. We're moving on.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this.
Yeah.
That's what you say.
Yeah.
But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. I don't understand why everything I say has to have some type of disruption title to it.
Because there are questions that they already answer. Everything is clear by now. Like I don't need, I'm in your same position. I don't know legal stuff and I'm still understanding everything that's going on. Why don't you?
Even been put on record numerous times with inaccuracy. Even what happened today. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet as if me, quote unquote, being disruptive was.
You being disruptive is what causes the bruises. If you would just walk away and sit on that chair that is right behind you, none of those bruises would have happened. That's on you.
Deserving of what happened to me.
Yeah, you deserve everything that is happening to you. Don't let's be clear about that. Just starting right there. Everything that you're doing, you deserve it.
Simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's
An apology without meaning it is useless.
the only way I can have clarity is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me.
Yes, that's how it works. You are the one that's on trial. That's usually how it works. The judge is not on trial. She studied, she worked, and that's why she's in the position that she is. So why are you saying that you're equals?
Where's the give and take? It should be fair.
Nah.
I'm not asking for legal advice.
Yes.
I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks?
You decided to represent yourself last minute. So it's on you. If you cannot read 3 boxes in 3 days, that's entirely up to you.
I'm not going to go through this with you again where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask
filings.
me questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions that are based in law and fact. I'm obligated to address objections, for example, but I am not obligated, sir, to provide you with an explanation of the law, of the procedure. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement.
Good. We're moving on. Nice. I just gotta say, it's gonna be so different when we go to other trials and I don't have to, and they're not interrupting every 5 minutes. It's gonna be so much different.
All right, at this time, we will give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes, thank you, Your Honor.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead, Attorney Wichow.
The event started off normal. There were dance teams, high school marching bands, local community groups, local businesses, all making their way down the parade route. The evidence is going to show that Mr. Brooks left behind a trail of carnage and chaos as he made his way down Main Street through the parade route. The evidence will show that he left that crime scene, created that crime scene, in fact, because he was fleeing from another one where he had laid his hands on a woman and where police involvement became inevitable. So as he careened down Main Street, swerving from curb to curb, hands glued to the steering wheel, eyes fixed on the road in front of him with a silent rage on his face, he hit the gas with his red Ford Escape and used it as a battering ram over and over again, striking men, women.
You see that? He rolled his eyes. Like, they're just specifically, factually saying what he did. And he's like, why do you have to tell them that?
And kids.
Kids.
In the end, Mr. Brooks killed 6 people. He injured dozens more and left a permanent scar on this community. We're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today. She's going to tell you that in November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st of 2021, the defendant showed up in Waukesha in his red Ford Escape that she knew he drove, and he argued with her, and he harassed her, and he punched her in the face. And the thing about a swollen eye,
He doesn't even... This is the thing that bothers me a lot, is that he doesn't take responsibility for what he does. Like, he was just accused of domestic violence. And he's like, ha! Did I punch her? Yes, I did.
is it's tough to fake. You're going to hear evidence about how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving. You're going to see how the defendant reacted once Erica's friends showed up and he lost his physical advantage over a woman. At some point during this scuffle, the police were called. The evidence is going to show that the defendant must have known, once things got loud and once there was more than just him and Erica on scene, the police were going to show up. So he took the coward's way out. You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over. Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school aged kids, there's video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymeyer Aparicio. She's going to come in and she's going to look at some still shots of the video. She's going to identify each of the 10 kids for you. You're then going to watch and listen to the video.
Look at that. He's smiling. Can you see that from his eyes? He looks like he's smiling about what he's hearing right now. Like, how sick do you need to be?
It'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day. I think it's important to point out you can't consider this evidence of each crime in a vacuum. You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people. You'll see in the video that at this point the defendant has actually increased his speed. In that area right before the Blazers got hit, the defendant was traveling in excess of 33 miles an hour. There were 5 victims in the Blazers. That includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8. He died 2 days later in the hospital.
Look at that. Look at that. Now he's fat. Like he puts his fingers in his eyes like tears were. There's no tears there. That's an act. Like there's no way that you do this to wipe tears off. Get out of here.
I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge provided the law to you. It'll be provided to you again at the conclusion of the trial. We're going to move further down the parade route, and the next group after the Blazers is the extreme dance group. There were girls of really all ages in this group, from toddlers being pulled in strollers up to high school age teenage dancers. 15 victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street near the 5 Points intersection, right in front of the extreme dance team as the defendant drove through. Girls in this dance group suffered catastrophic injuries. The group of victims also includes parents, grandparents, siblings, people marching with the group. The next group down the parade route is Citizens Bank. And here we reach the second count of intentional homicide. Jane Kulik was marching with Citizens Bank with her friends, with her co-workers. This is the only count of homicide for which there is no clear video depicting how she died. You're going to hear...
See how he doesn't do the eye thing for her? He just kind of prayed for some reason. That doesn't invalidate what you did. But you see how different he reacts to the different victims?
There are about 3 kids who were standing along with a bunch of others along the curb in front of Steaming Cup. And as the defendant swerved from the left side of the street as he hit Jane back to the right side of the street as he was avoiding the vehicle that was ahead of him, clipped the curb and hit these 3 kids. Then we're going to move in to the next group in the parade route, which is the Dancing Grannies. This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the Dancing Grannies group, who will come in and they will describe being completely caught off guard. You will learn about Bill Hospital, who was marching in a support capacity. He was there to support his wife Lola and their friends, the rest of the Dancing Grannies, just walking along the parade route trying to be helpful. And as the defendant swerved around the Dancing Grannies vehicle, which is a white SUV, you'll see it in the video, swerved around the right side, he hits Bill. And the medical examiner is going to tell you that Bill Hospital cause of death was multiple blunt force traumatic injuries. You'll learn about Tamara Durand, marching with the Grannies, cause of death, multiple blunt force traumatic injuries. You'll hear about Lee Owen, another Dancing Granny, walking in a winter wonderland when she got hit. You'll learn about Jenny Sorensen. You'll learn that Jenny was walking at the front of the group carrying the banner. You'll see video of Jenny getting struck. At that point, where the defendant crashed through the Dancing Grannies group, he was traveling at approximately 32 miles an hour. The eighth and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. We're going to be efficient, but we have a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with the evidence, to find the defendant guilty of each and every count. Thank you.
I think that was a really good presentation. Like, it just laid out the information. Like, this is what happened. This is what we're gonna show you. That's it. We believe that just showing you this is gonna get you enough proof to send this guy to jail forever. I like it.
Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case, meaning the defense portion of the case?
I will be deferring at this time, Your Honor. I need a little more adequate time to make sure I go over the points that I need to make.
And remember, like, you're gonna see it if you're watching this first. You're gonna see when he gets to do his opening statements, he has no points at all. Like, at all.
All right, then the court will honor that request, advise the jury he's deferring his opening statement until a later point in the proceedings.
Her transportation is also difficult, and so she's here and ready to go if the court would indulge those two witnesses this afternoon.
It certainly seems reasonable. Mr. Brooks, my question to you then is, do you want to come back over for the testimony of those witnesses?
Yes or no?
I would prefer to. I'm still kind of taken aback by not being able to know exactly how many witnesses are expected to testify, and not being able to turn in my own witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline what will be presented at trial versus what is in discovery, so you've had ample opportunity to review those. I'm happy to bring you back. You, of course, will have an opportunity.
Yeah, he's still claiming ignorance, even though there is proof that he was given all those things. So, what else do you need to hear about that? Just look at the information.
To cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object?
Some objections really are 1 word. Hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
So that's a no then.
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
But she's asking you.
That's why I'm asking the clarification question, sir.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir, I think
You're in the other courtroom. That means that you haven't.
a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately. I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
Yes or
I
no?
have to the best of my ability.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I would have just cut him off right there. Like, I'm done with you. I'm done with you. You stay in there. Whatever. Bring the witness out. Like, I'm done. Like, he's playing right now. Like, he's just playing dumb, basically. And like, I would have been, you know what? Stay there.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of two witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these two witnesses. Yes or no?
I'm going to end up getting put back over here eventually.
That
if
means
I come
no.
over there.
Mr. Brooks,
That means no. You're saying no then. Then stay there.
I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these two witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is. You will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir.
Can you tell me what you mean by non-responsive?
No.
You did not answer yes or no.
Yeah.
All right, do we need to
So
back
that's
out?
taken as being non-responsive?
Yes.
Excuse me, Your Honor.
You muted him.
Can I say something for the record?
Do you think with where that chair is, the witness will
I'm
be?
going to ask the witnesses to have to stand where
I like what they're doing right now. I like that they're ignoring him and just moving on.
am so that everybody can see.
Oh, that would be a good idea.
Okay.
No, you're not muted yet.
Yet.
Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be.
Because I didn't answer your question the way you wanted to.
All right, I'm going to mute you, sir.
The blue boxes are the name.
We're gonna come back with the witnesses on the next part. Thank you guys so much for watching. We're almost done with the whole trial, so I want to thank you guys for sticking by with me while we do that. Have a great day. Bye bye.